Hi, everybody. We're going to give people a minute to come in. Thank you for joining us today. Thanks for joining us. We're just going to give people a little bit of time to come in. We'll be starting in just a little while. Great. While there's still people coming in, we want to get going because we have a lot to cover. Welcome today. My name is Stephen Rothstein, and I'm the Managing Director of the Ceres Accelerator. We have a action-packed agenda. We clearly we want to talk about the March 6th decision, but before we get to the substance, there are a few more administrative things I want to get to. First, let you know that this is being recorded. It will be posted on our website and shared with all of you later. If you need closed captioning during the meeting, please select CC or closed captioning. It has been enabled for you. We are going through many of the questions that have been submitted. We had literally dozens and dozens of questions that were submitted. We've put them together. And we won't get to all of those, but as many as we can. If you have additional questions after the event, please reach out to secrule@ceres.org, and I'll mention that again later. secrule@ceres.org if there are questions after the event. We'll also share links to the relevant elements in the chat and in the follow-up note. To advance our work to build a just and sustainable future, we're committed to our work around diversity, equity, inclusion, and justice. This includes elevating the voices on those communities most impacted by the very real consequences that we're discussing today. We welcome your potential partnership in that. Stay tuned for what it looks like in practice. I also just want to thank all of you for joining and for the Ceres staff for the 20 years of advocacy, which we'll talk in more detail. Next slide, please. I'd ask you to take just a second. Again, this will go out as well, just to look at this language, just from a disclaimer perspective. Next slide, please. This has some background on Ceres. I won't go through a lot of detail. Many of you know Ceres, and if not, we're happy to share more. But Ceres, as I say, has been honored to do this work, and our CEO will talk more about that. Next slide, please. We're really thrilled to have 3 external speakers in addition to the remarkable team from Ceres, Paul Munter and Erik Gerding from the SEC. Paul's the Chief Accountant. Erik is the Director of the Division of Corp Finance. And just take this time to thank both them and the dozens or maybe hundreds of staff that worked on this, as well as the chair and the other commissioners. They worked very hard, and give them enormous credit for their work. Next slide, please. These are the folks, Ceres staff, plus Rich, who's joining us from the Edison Electric Institute. So we appreciate all of their leadership throughout the work, throughout the year and years to work on this effort. And again, Rich, thank you for joining us and the partnership with the EEI. Next slide, please. One of the basic concepts behind this rule, which is not a new news to anyone on this call, is that climate risk is financial risk. But when Ceres started this conversation, that was something new. You all aware that there have been a number of actions taken since March 6th, when the SEC released this 886-page document, of which about 30 pages are the rule, and the other is incredibly helpful notes and footnotes and background context of their deep analysis. There have been 9 lawsuits. They have been consolidated into the Court of Appeals in the 8th Circuit. Last week, many of you know that the SEC voluntarily, they proposed a stay. And while they did that, they said, and I'm going to quote, that they will continue to vigorously defend the final rule and look forward to an expeditious resolution of the litigation, unquote. Ceres obviously is very supportive and moving forward, and the purpose of today is to share more information about this with all of you, and because the timelines, it's important to move forward. Next slide, please. Just in the interest of time, not going to go through this in context, but it's just important to put a footnote that this is in the context of enormous effort around the world, and in the state of California, which affects obviously thousands of companies across the country. So with that, I'm going to turn this over to Mindy Lubber, who's been working on this for 20 years, and give her enormous credit for leading our effort. Mindy, over to you.
Great. Good to have all of you. And I'm laughing only because think about 20 years. We need to move quicker, but we are, let's call this an important win. Despite litigation and noises background, this is an important step forward. And with this rule, investors will now have access to decision-useful data in financial filings. I want to thank SEC Chair Gensler, as Stephen did, his fellow commissioners, the remarkable staff, of which we're privileged to have two joining us, in the hard work they did. Promulgating this rule was no small task. Tens of thousands of comments to read and respond to. I know how much thought went into this, and as a former regulator, how much work went into this. 20 years ago, and I'm not going to give you the long story of where I was 20 years ago, because it almost seems crazy that this took 20 years, but time marches on. 20 years ago, we worked with a handful of investors who wanted and had the foresight to ask the US SEC to improve climate risk disclosure, to require the material risk of climate and related sustainability issues as material risks when they were. And now we are preciously close to having this consistent, comparable information on all physical and transition risks, which is clearly vital to decision-making around strategy, investments, and voting. As the adage goes, and it's probably more overused than most, you can't manage what you can't measure, but it's true. Investors have asked for this information so they can manage their own portfolios and ensure the long-term value for shareholders and their clients. And considering the material risks of climate, of water, of related material risks is simply part of the fiduciary duty that an investor holds. The rule is unquestionably an important step forward, an enormous improvement over the status quo of fractured voluntary disclosure. The basis of the rule that the climate crisis poses significant material financial risks is now clear and undeniable. If anybody questioned us 20 years ago, I believe we had the facts then. But today's world, it is only waking up and seeing what we're living to understand how clear and undeniable it is. A brief example of this can be seen in the SEC's decision to integrate material physical risks from events such as drought, wildfire, and floods into the rule. These extreme weather events are making water access scarce, polluted, and unpredictable. These changes are impacting companies and financial markets by disrupting production, shipping, undermining our productivity, and damaging and idling assets, ranging from factories to farms. It is crucial information, and because the SEC has mandated this information in filings, investors will finally get insight into how companies are managing material risks related to climate change. And just like they do with any other operational supply chain risks or whatever, be inflation or labor shortages or a global pandemic, these risks need to be integrated. It is critical for US capital markets. And while we all know we're disappointed that the final rule does not mandate the disclosure of Scope 3 emissions, investor demand for the disclosure of these emissions will continue to grow, and many companies will be required to disclose this information in other jurisdictions. There is a clear international march to mandate the disclosure of all emissions because of the growing financial risks associated with them. The momentum, clear and undeniable. And moving forward, We urge companies to continue to disclose this information as they work to deliver on their climate commitments and align their business strategy, not just SEC disclosure, but a transition plan for how to get there. Many companies have made long-term commitments, transition plans, science-based targets to reduce their emissions in line with limiting global temperature rise. For those who have not, we encourage them to do so. And while it is beyond the scope of the SEC's authority to mandate that, we do encourage all companies and institutional investors to create and implement comprehensive climate transition plans that address the need for clarity on how they are moving from setting goals to achieving them to reach the UN climate targets. These transition plans are crucial for a framework for action for corporate boards to see investors, governments, and the public who need information. Time is now. The pushback is real that we're seeing on the SEC. It is unfortunate, particularly since we are simply talking about providing adequate, relevant material risks to investors. The SEC has said they're going to keep moving, and we are urging all to keep moving, to keep up with other parts of the world, to make sure investors have the information they need, and truly to help corporations ground their commitments into words and deeds, risks, and opportunities. Thanks very much.
Thank you, Mindy. Thanks so much. So now, as I said, we're thrilled to have Erik and Paul joining us from the SEC. I'm going to turn over them for introductory comments. I'm also going to ask Jake, and at the end of the introductory comments, Jake and Tom to come on to coordinate the question and answers. Erik and Paul.
So thank you, Stephen. Thank you, Mindy, and thank you to Ceres for having Paul and I today. I do need to start out with our standard disclosure, or standard disclaimer. The views we express today are provided in our official capacities as the Commission's Director of the Division of Corporation Finance and Chief Accountant, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. So I will start by giving an overview of the rules, and then we will turn it over back to Ceres to lead Q&A. Before going into the overview, I should note that, as we heard a moment ago, the Commission last week did issue an order staying the final rules. Pursuant to that order, the final rules are stayed pending the completion of judicial review of the consolidated petitions in the Eighth Circuit. The Commission's rationale for staying the rules is described in the order, which is publicly available on the Commission's website. Neither Paul or I can talk about the ongoing litigation or discuss anything with respect to the stay beyond what is contained in the order. We can, however, discuss the final rules themselves and what the Commission said in the release adopting the final rules. So with that, let's get into the overview. I want to start out by making a few overall substantive framing points that are in the adopting release. First of all, the rules are focused on investor needs and providing investors with information to make investment and voting decisions. Investors are already demanding and using much of the climate-related information that the rules require. And many registrants are already disclosing the climate-related information that the rules would require. But what the Commission found is inadequate, and what the rules are designed to address is to bring further consistency, comparability, and reliability to those disclosures. Another final framing point: when the regulations use the word materiality, despite what you might hear elsewhere, it is the same meaning of materiality that is set forth in Supreme Court case law and in existing Commission rules. Let me turn now to an overview of the rule. The rules, what is a change after the adoption of the final rule from what would be required under existing SEC rules. I'll talk first about disclosures in Regulation SK. Regulation SK are disclosures that are required outside of the financial statements. And the final rules require both narrative disclosures, but also some quantitative disclosures and metrics. I'll then turn to Regulation SX, the disclosures that are required in the financial statements themselves. And then Paul will answer questions related to the SX financial statement disclosures, and I'll answer questions related to Regulation SK. So in Regulation SK, the final rules would require disclosure of climate-related risks that have had or are reasonably likely to have a material impact on the registrant's business strategy, results of operations, or financial condition. Second, the final rules would require disclosure of the actual and potential material impacts of any identified climate-related risks on the registrant strategy, business model, and outlook. Third, the final rules will require that a registrant disclose that if, as part of the registrant strategy, it has undertaken activities to mitigate or adapt to a material climate risk, it would have to disclose a quantitative and qualitative description of material expenditures incurred and material impacts on financial estimates and assumptions that directly result from such mitigation or adaptation activities. Another part of the final rules would require specified disclosures regarding a registrant's activities, if any, to mitigate or adapt to a material climate-related risk, including the use, if any, of transition plans, scenario analysis, or internal carbon prices. Another feature of the final rules would require disclosure of any oversight by a registrant's board of directors of climate-related risks and any role by management in assessing and managing the registrant's material climate-related risks. Let me catch my breath for a minute. The final rules would also require disclosure of any processes that the registrant has for identifying, assessing, and managing material climate-related risks, and if the registrant is managing those risks, whether and how any such processes are integrated into the registrant's overall risk management system or processes. And a final piece of largely narrative disclosure in Regulation SX, required disclosure about a registrant's climate-related targets or goals, if any, that have materially affected or are reasonably likely to materially affect the registrant's business, results of operation, or financial condition. These required disclosures would include material expenditures and material impacts on financial estimates and assumptions as a direct result of the target or goal or actions taken to make progress toward meeting such target or goal. As was mentioned earlier, there are also GHG emissions disclosure requirements. So for two types of registrants, for large accelerated filers and accelerated filers that are not otherwise exempted, these types of issuers or registrants will be required to disclose material scope 1 emissions and or material scope 2 emissions. A couple of other provisions that I should note. There are extended phase-in periods. There is a safe harbor from private liability for climate-related disclosures, excluding historic facts pertaining to transition plans, scenario analysis, the use of an internal carbon price, and targets and goals. There is an exemption from the GHG emissions disclosure requirements for smaller reporting companies and emerging growth companies. There is also an accommodation that allows scope 1 and or scope 2 emissions disclosure, if those are required, to be filed on a delayed basis as follows. So domestic registrants can file these disclosure requirements in the Form 10Q for the second fiscal quarter and the fiscal year immediately following the year to which the GHG emission disclosure relates. For foreign private issuers, they can file these disclosures in an amendment to the registrant's annual report on Form 20F, which shall be due no later than one such disclosure would be due for a domestic registrant. If filing a Securities Act or Exchange Act registration statement, the disclosure would be required for the most recently completed fiscal year, that is at least 225 days prior to the date of the registration statement. Paul, let me hand it over to you at this point.
Great. Thanks very much, Erik. So picking up where Erik left off on the disclosures of scope 1 and scope 2 emissions, the final rules also require an assurance report to be provided on the scope 1 and or scope 2 emissions by applicable registrants. The level of assurance would begin at the limited assurance level, and for large accelerated filers, it would scale up to a reasonable assurance level after an additional transition period. Specifically with respect to the assurance requirements, the attestation provider is required to be independent of the issuer and to meet certain expertise requirements. The attestation report to be provided would be based upon standards that are publicly available at no cost or that are widely used for GHG emissions assurance and that are established by a body or group that has followed due process procedures, including broad distribution of the framework for public comment. The attestation report itself is required to follow the form and content of the requirements of the framework that is being used by the attestation provider. And then there is a requirement to have disclosure of certain information by the registrants outside of the attestation report regarding the existence of any oversight or inspection programs to which the provider or the engagement is subject, and whether there has been a resignation or dismissal of the former GHG emissions attestation provider and any disagreements between the service provider and the registrant. And in circumstances where a registrant voluntarily obtains third-party assurance over his GHG emissions disclosure, the registrant is also to include in its filing information including the name of the service provider, the level and scope of the assurance provided, and the results of the assurance. Now, next, turning to the financial statement disclosures, as Erik described earlier, we have requirements outside of the financial statements that Erik described that are identified by Regulation SK, and then financial statement disclosure requirements that are identified by new Article 14 of Regulation SX, which requires the registrant to disclose certain disaggregated financial statement information in a note to its consolidated financial statements. The required financial statement disclosures can basically be broken down into three categories. First is disclosure of capitalized costs, expenditures expensed, charges, and losses incurred as a result of a severe weather event or other natural condition, such as hurricanes, tornadoes, flooding, drought, wildfires, extreme temperatures, and sea level rise. That disclosure is subject to a 1% disclosure threshold and certain de minimis thresholds. In preparing these disclosures, the registrant is not required to determine that a severe weather event or other natural condition was caused by climate change before the disclosure is required. Further, registrants will need to determine what constitutes severe weather event or other natural condition based on the particular risks faced by the registrant, taking into consideration the registrant's geographic location, historical experience, and financial impact of the event on the registrant, among other factors. In addition, the final rules include an attribution principle that provides that a cost, expenditure, charge, or loss resulting from a severe weather event or other natural condition, when the event or condition is a significant contributing factor to incurring the amount. The second category of financial statement disclosure information is a requirement to disclose capitalized cost, expenditure expense, and losses incurred in connection with the acquisition and use of carbon offsets and renewable energy credits if used as a material component of the registrant's plans to achieve its disclosed climate-related targets or goals. And the final category of information a registrant is required to disclose are the financial estimates and assumptions that were materially impacted by severe weather events and other natural conditions, or a registrant's disclosed targets or transition plans. In addition, with respect to the disclosures that I've just described, the final rules require a registrant to disclose contextual information that will enable investors to understand how the registrant derived the required disclosure, including a requirement to disclose any recoveries recognized during the fiscal year as a result of severe weather events or other natural conditions for which costs and expenditures are disclosed. These disclosures are to be provided for the registrant's most recently completed fiscal year and to the extent previously disclosed or required to be disclosed for the historical fiscal years for which audited consolidated finance statements are included in the filing. Or said another way, these disclosures will be required for historical fiscal years included in a registrant's consolidated finance statements on a prospective basis only. As Erik mentioned, there are phase-in provisions for these requirements for all registrants, with compliance dates dependent upon the registrant's filer status and the content of the disclosures. And with that, I think that summarizes the requirements of the rules, and Erik and I are happy to answer questions, time permitting.
Great. Thank you so much to Erik and Paul for that overview. I'm Jake Raskoff. I'm Director of Climate Financial Regulation within the Ceres Accelerator for Sustainable Capital Markets. I'm joined by my colleague, Tom Riesenberg, our Senior Regulatory Advisor. So we are now going to be moving back and forth between Erik and Paul, posing questions related to the Regulation SK and SX parts of the rule. And so we are going to start with a topic that I know is top of mind for a lot of attendees on the webinar, and that is emissions disclosure. So again, many of these questions come from ones that were submitted by attendees. So thank you to everyone who did. We know this won't cover everything, but within the time we have, we hope to get through a lot. So Tom, take it away.
Thanks, Jake. Thanks for everybody, and thanks, Erik and Paul, for joining us. So you touched upon a very significant issue that everybody has questions about, which is materiality. Of course, the SEC rule changed from its proposal to its final rule, and people are now wrestling with materiality. The SEC release, the adopting release, gives some examples of how do you look at the materiality of emissions. I wonder if you can expand on that. You know, also, one element of this, I've read a few things where people are saying, well, now that materiality is in the rule, it's all a voluntary rule. This is no longer a mandatory rule, which of course mischaracterizes the whole nature of the SEC regulatory process. And but if you have some observations, Erik, in particular, you can share on those points, that would be helpful.
Sure, Tom. Thank you for the question. So as I mentioned in my framing remarks, nothing in the final rules changes the materiality standard that is generally applicable under the federal securities laws. It's the same materiality standard that was articulated by the Supreme Court in case law, and that the Commission has defined in Rules 12b-2 of the Exchange Act and Rule 405 of the Securities Act. So this is materiality is not a new concept to securities laws, and we are not adopting, or the Commission is not adopting, a new materiality standard. What is that standard? The Supreme Court stated in a case called TSC Industries versus Northway, and in a second case called Basic versus Levinson, that information is material if there is a substantial likelihood that a reasonable shareholder would consider it important in making an investment decision, or if it would have significantly altered the total mix of information made available. So when the word material appears in the final rules, including with respect to Scope 1 and Scope 2 emissions disclosure, it's referring to that traditional notion of materiality. As many in the audience know, materiality is a facts and circumstances-based inquiry. That's why the Commission generally highlights the standard itself rather than giving examples of what would be per se material or per se immaterial. The adopting release does give, however, some examples of situations in which Scope 1 and or Scope 2 emissions may be material. And I would encourage the audience to actually read the adopting release and not just the reg text to get a lot of this background information. Some of you may already be familiar with the examples in the adopting release, but I'll share them again for the sake of the audience, as they may be helpful in guiding materiality determinations with respect to scope 1 and 2 emissions based on different facts and circumstances. So here's the first example that the Commission discussed. A registrant's scope 1 and/or scope 2 emissions may be material because their calculation and disclosure are necessary to allow investors to understand whether those emissions are significant enough to subject the registrant to a transition risk that will or is reasonably likely to materially impact the registrant's business, results of operation, or financial conditions in the short or long term. So you can think of this as transition risk as shorthand, material transition risk as one shorthand for the first example. Second example, the Commission discussed that a registrant's GHG emissions may also be material if their calculation and disclosure are necessary to enable investors to understand whether the registrant has made progress towards achieving a target or goal, or a transition plan that the registrant is required to disclose under the final rules. Conversely, the fact that a registrant is exposed to a material transition risk does not necessarily result in its scope 1 and 2 emissions being de facto material to the registrant. For example, a registrant could reasonably determine that it's exposed to a material transition risk for reasons other than its GHG emissions, such as a new law or regulation that restricts the sale of its products based on the technology it uses that is not directly based on its emissions. However, such a risk may trigger disclosure under other provisions of the final rules.
Great. Thank you so much, Erik. So that dealt with scopes 1 and 2 disclosure, which are now mandatory if material. So as many people know, the original proposal would have also mandated scope 3 disclosure if material, or if the registrant had set a target or goal that included scope 3. So we know the final rule does not require registrants to disclose scope 3 emissions anymore, but there may be circumstances in which other provisions of the rule result in such disclosure. So maybe if a registrant adopts a target relating to scope 3 and in achieving that target invokes material costs. So could you go into a little bit of detail on whether there will still be occasions where the SEC might require scope 3 disclosures?
Jake, I have to reiterate that the release does not call for disclosure of scope 3 emissions, and the release does specify that no circumstances are scope 3 emissions metrics disclosures required. I know that there's been some press on the issue and that there's questions arise among some practitioners about whether there is some backdoor requirement to disclose scope 3 emissions, perhaps through the transition plan or targets and goals disclosures in the final rules. Although the adopting release is very clear on the point to address any remaining uncertainty, I have to reiterate that none of the final rules mandate scope 3 emissions disclosure. So again, under the final rules, scope 3 emissions is strictly voluntary. That said, there may be some instances in which qualitative disclosures with respect to scope 3 could be required. That could come through the example of transition plan disclosures under item 1502E1. Item 1502E1 states that if a registrant has adopted a transition plan to manage a material transition risk, describe the plan. Where a registrant has adopted a transition plan to manage any, quote, material transition risk, it will need to describe the plan. This will include a description of what the plan covers, but it does not necessarily require, or does not require quantification of the matters covered by the plan.
Great, thank you, Erik. That's very helpful. Paul, turning to you for a moment for financial statement disclosures. So the proposed rule would have required the disclosure of both expenditure metrics, which is included in the final rule, as well as financial impact metrics, which was dropped out of the final rule. So can you explain how those impact metrics differed from expenditure metrics and how the SEC reached the decision to eliminate the former while keeping the latter?
Yeah, happy to, Jake. So as you note, the proposed financial impact metrics would have required disclosure of the impacts of severe weather events or other natural conditions and any efforts rather to reduce GHG emissions or otherwise mitigate exposure to transition risk on line items in a registrant's financial statements. The disclosure of financial impact metrics would have been required if the sum of the absolute value of all the impacts on the line item was 1% or more of the total line item for that particular fiscal year. The proposed expenditure metrics would have been required for registrants to disclose expenditures, expense and costs incurred to mitigate risk related to the same weather event, other natural condition, and transition activities. And for each of the two categories, registrants would have been required to separately aggregate the amounts of expenditures expensed, costs capitalized that were incurred during the year presented. Disclosure of these amounts would have been required if, again, the aggregate amount of the expenditures expensed and the aggregate amount of the capitalized cost was 1% or more of the total expenditure expensed or total capitalized cost incurred for the relevant fiscal year. As you noted, we got a lot of input to not just this, but all parts of the proposal. And while certainly there was some support in the comment file for the proposal to require disclosure of financial impact metrics, many of the commenters who did provide feedback on the proposed financial impact metrics did not support the proposed requirements. And a number of the commenters asserted that it would not be feasible to provide the disclosures, at least as proposed. And so while the proposed financial impact metrics would have provided additional transparency for investors, we were persuaded by the comments and the commenters that stated the proposed financial impact metrics would be burdensome and costly for registrants because of updates that would be necessary to internal systems and process requirements. And so as the adopting release explained, these concerns led to the adoption of significantly narrower set of requirements focused on a requirement to disclose a discrete set of actual expenses that are recorded in the registrar's books and records, with the expectation that these requirements would be feasible for registrants to disclose under the current financial reporting processes. And then, moreover, given the overlapping nature of some of the disclosures that would have been required by the proposed financial impact metrics and the capitalized costs, expenditure expense, charges, and losses that are required to be disclosed under the final rule, the requirements provide many of the same benefits of transparency and insight that the proposed financial impact metrics would have provided, although in less detail, but also that balances the need to reduce the burden on registrants.
I'm going to ask the next question following up on the same general area because it's something that I think people are wrestling with, Paul. So with respect to the financial statement disclosure, as has been noted, the rule requires disclosure of severe weather events and other natural conditions, and it actually specifies hurricanes, tornadoes, flooding, drought, wildfires, extreme temperatures, sea level rise. How does the company figure out what's meant by in particular a natural condition? I've heard people say, for instance, you don't mention earthquakes. Is that a natural condition, or is that it's not necessarily climate related, but does that make any difference? I know doesn't have to be caused by climate change, but would that be included? If you could just expand upon that. And we have a bunch more questions, so we'll try to go through these as quickly as we can.
Yeah, sure, Tom. So kind of getting to the last part of your question first, as I mentioned in the tee-up, the final rules do not require registrants to make an assessment as to whether a severe weather event or natural condition is a consequence of climate change or is climate related. Neither of those are required. In the final rules, we concluded it was appropriate to have a principles-based approach. And so the final rules do have examples of severe weather events or other natural conditions. Those examples are not intended to be an exhaustive list, but only examples. And so as a consequence, registrants will need to determine what constitutes severe weather event or other natural condition based on the particular risk faced by a registrant, taking into account their geographic location, historical experience, the financial impact of the event to the registrant, among others, using, like say, the examples as a starting point, but not an ending point to their analysis. And so while the determination of whether an event or condition is severe does require judgment, we think registrants already have experience exercising judgment in the development of their financial statements in a lot of areas, but in particular, under US GAAP, there is already a requirement to disclose the financial statement impacts from events that are either unusual in nature or infrequently occurring, many of which may be either severe weather events or other natural conditions. So we don't think this is a concept that will be unfamiliar to registrants who have long been in the habit of having to exercise judgment in evaluating how accounting and disclosure requirements apply to their specific circumstances.
So in other words, just to recap, a natural condition could be totally unrelated to weather. Is that correct?
A natural condition could be totally unrelated to weather. The other thing I guess I should also touch on real quickly is I mentioned the attribution principle, that if the severe weather event or other natural condition is a significant contributing factor, then the entirety of cost capitalized or expenses expensed would be included in the disclosure, and there's no apportionment process that goes on. So take the circumstance where, for example, a registrant's factory facility is damaged by a tornado. The tornado is the severe weather event, or a registrant might determine the tornado to be a severe weather event. And notwithstanding the fact that the overall condition of the building, how old it was, its state of upkeep and all that would be part of the formula in terms of what are the costs they might incur in response to that, because the severe weather event is the tornado and it is a significant contributing factor, then all of the relevant costs and expenses would be captured by the disclosure requirements, subject, of course, to the 1% and de minimis thresholds.
And could I just real quickly expand on the significant contributing factors? You raised it, and this is another thing that I think a lot of people are wrestling with. So is there any indication of how you measure the word significant? And I've seen some accounting firms refer to the ASC 320% test, for instance. Is that something you would condone or sanction, or something else?
So we do not have any percentages included in the rule or the related discussion around it. The use of the term significant appears in many places in US GAAP. In ASC 323, it is used, and there is a 20% indicative percentage that's included in there, but that is by no means the only place in US GAAP where the term significant is used. And I would observe that in the vast majority of times where the term significant is used in US GAAP, it is used without any kind of percentage threshold. So you will note that our discussion does not have any percentage threshold. And we think that a registrant would need to apply judgment in determining whether a severe weather event is a significant contributing factor.
Okay, that's nice. One more quick question. I'm going to turn it back to Jake. So the financial estimates and assumptions requirement disclosure, just clarify real quickly as to where that appears. It's in the financial statements. Is there any component in SK narrative discussion as well?
Yeah, so that's covered by in SX Rule 1402H. Yep. And under that rule, registrants will be required to disclose whether estimates and assumptions the registrant used to produce its consolidated financial statements were materially impacted by exposure to risk and uncertainties associated with or known impacts from severe weather events and other natural conditions, as we touched on earlier. That is basically leveraging off of the more general requirements in ASC 250, which has disclosure requirements about changes in estimates as subject to materiality, as is the case for GAAP requirements. But these requirements are specific to changes in estimates and assumptions as a consequence of severe weather events or other natural conditions. Now, as you mentioned, there are other required disclosures that Erik covered pursuant to SK that are related to material impacts on estimates and assumptions as a direct result of activities to mitigate or adapt to climate-related risks, transition plans to manage a material transition risk, and material impacts of a direct result of disclosed targets or goals or actions taken to make progress toward meeting targets or goals. The adoption release notes that with respect to these requirements in subpart 1500, to the extent that the information is disclosed in response to Rule 1402H of SX, the registrant is able to cross-reference to the disclosures that would be provided in the financial statements.
Great. Jake, back to you.
Thank you, Paul and Tom. Erik, one question for you. So something you often hear from opponents of the rule is that if these risks were material, companies would already be disclosing them. And the status quo that SEC registrants operated under prior to the adoption of this rule was the 2010 interpretive guidance on how companies might consider disclosing material risks. So if despite that 2010 guidance, a registrant has not made a climate-related disclosure in prior years because they've concluded a lack of materiality, should the registrant now be concerned about reaching a different materiality conclusion pursuant to this rule, that is, concluding that the climate information is material and should be disclosed, even though they haven't disclosed it in the past?
So, Jake, let me sort of reiterate, sorry to sound like a broken record. Materiality is the same standard that it was before the final rules were adopted, that it is now. And what the run through of the SK rules that I did and the run through of the SX rules that Paul made are different and new compared to what the status quo was before the commission adopted the rules. So there are new line items of disclosure or new disclosure items in both SX and SK that were not there before. So those are new substantive rules that were not there when the 2010 guidance was adopted. I should note again that materiality is a very facts and circumstances intensive inquiry. And the materiality of a particular climate-related risk as it pertains to a particular registrant could change over time. And this is true with respect to any of the other items that are required under the final rules, including, for example, a transition plan or a target or goal. And the release notes that, again, materiality is a facts and circumstances inquiry, and it could change over time with respect to a particular registrant. So let me give you one example. With respect to both transition plans and targets and goals, the release does note that registrants would not be required to continue to provide updates on previously disclosed transition plans or targets and goals if the transition plan is no longer used to manage the material transition risk, or if a target or goal is no longer material. But as such, the reverse is also true. A registrant may reasonably have determined in prior years that a particular climate-related risk was not material at that time, but it may have since become material to the registrant. And again, Jake, let me sort of ask that the audience members look at the discussion in the actual text of the release and not just the rule text. There's a lot of good discussion on how these provisions work and a lot of good examples in the actual adopting release.
Thank you, Erik. So we only have a few minutes left for the Q&A here, so we'll try and run through a few more. Ceres works with a lot of companies who voluntarily set transition plans or are contemplating doing so. And as Mindy mentioned, we certainly want more companies to contemplate doing so. And the final rule, the adopting release, acknowledges commenters who asserted that the transition plan disclosure requirement might act as a disincentive to the adoption of a transition plan. So can you address some of those concerns and maybe explain why the final rule should not disincentivize companies, or if you feel that that concern is warranted, just expand on that a bit.
Yeah, so as you noted, Jake, the Commission did recognize commenters' concerns that the level of detail required under the proposed rules, under that transition plan disclosure requirement, could have discouraged registrants from adopting a transition plan that they otherwise might have adopted in order to avoid having to describe that plan in detail. But note, these comments were made with respect to the proposed transition plan disclosure requirement. The Commission adjusted the final rules so as to address these concerns. So, for example, the final rules transition plan disclosure requirement is significantly more streamlined and doesn't require the same level of detail or prescriptiveness as the proposal would have. Instead, a registrant is required to disclose the transition plan disclosure with flexibility to provide disclosure that addresses the particular facts and circumstances of its material transition risk. In addition, under the final rules, a registrant's transition plan disclosures are subject to a safe harbor from private liability, which should mitigate some concerns that registrants have expressed about making the required transition plan disclosures.
Great, thank you, Erik. And another question for you is, rule appears to state that governance disclosures must be made regardless of materiality, at least in some cases of governance disclosures. But the adopting release also states these disclosure requirements apply to those registrants, the boards of which exercise oversight of climate-related risks. No disclosure is required for registrants that do not have information responsive to the disclosure requirements. So I guess in that circumstance, does this mean that if a registrant determines they face no material climate risks at all, no governance disclosure is required? And I guess that gets to the broader question of, does the SEC have any role in assessing the quality of registrants' climate risk management?
So let me take that last question first, Jake. We are not, the Commission and the staff are not dictating any particular governance or risk management strategy. So the release notes that the Commission is agnostic as to how registrants address climate risks through government or risk management. But in terms of answering your question about board oversight disclosures, it's really helpful to look at the precise language of the rule text. So item 1501A requires a registrant to describe the board of directors' oversight of climate-related risks. And as you noted, Jake, there's no materiality qualifier in this part of the rule. So the disclosure requirement is not limited to the board's oversight of material climate-related risks. The adopting release explains why the Commission did not adopt a materiality qualifier for this provision, and it stated, and I quote, "If a board of directors determines to oversee a particular risk, the fact of such oversight being exercised by the board is likely material to investors given other demands on the board's time and attention." And the release also stated that we expect that any risks elevated to the board level will be material to the company and limited in number. As you noted, Jake, the release also notes that no disclosure is required for registrants that do not have information responsive to item 1501A. So I would slightly reframe the question. It's not necessarily whether the registrant faces material climate-related risks. Instead, it's whether a registrant must make disclosures in response to item 1501. And that depends on whether its board of directors oversees any climate-related risks that the company faces.
Thank you so much, Erik, and thank you, Paul. We do unfortunately have to wrap the Q&A session, so thank you so much for all your insights. And now we'll move to another portion of the agenda
Can
here.
I make one final point? I think this
yes.
might be helpful. Again, I would really encourage your audience to read through the adopting release and the reg text in detail. There's a lot in there that goes beyond the highlights, and there's a lot in there that I think is very, very valuable for investors and their investment and voting decisions. And then, this sounds super nerdy, Jake, but pay attention to the footnotes, because the footnotes explain a lot about the responses that we made, or the commission made, to commenter concerns. And not just sort of the changes to the proposing release, but the actual provisions that are in the final provisions that the commission did decide to adopt. And if you look at those footnotes, you see where the commenters support and where investors support, including perhaps a lot of people who are in the audience, where that investor support led or helped lead to provisions in the final rules. So if you want to see the impact of commenters on the final rules, including the impact perhaps of many people in the audience, go read the release and look at the footnotes and see just how seriously we took commenter concerns, commenters critical of the release, and also commenters who were supportive of the proposed rules and supportive of the disclosures that were ultimately required. So sorry to pontificate a little bit, Jake, but I did think that was really important for this audience to hear.
It's an excellent point to end on. Thank you, Erik, for that. And I'll add that for any attendees who do not have the capacity or interest to read the entire adopting release, that is why the Ceres team is here, and we have done so. So please reach out to us if we can be of help with any of this. So now I have the pleasure to introduce Richard McMahon, who's the Senior Vice President for Energy Supply and Finance and Chief ESG Officer for the Edison Electric Institute. Rich leads industry activities on energy supply, including natural gas, renewable energy, and energy storage. He also leads EEI's Wall Street activities, including financial analysis, investor relations, accounting, and tax issues. So, Rich, please take it away with some comments on the final rule from your industry's perspective.
Well, thanks, Jake. Really appreciate it. And also compliments to Ceres on your leadership over the years. Mindy, Stephen, Dan, the whole Ceres team, you've really done an outstanding job. We looked at the rule, first of all, Edison Electric Institute and our member electric utility companies have been doing voluntary ESG disclosures. We have a template that we put in place more than 7 years ago. The template was put together with investors. So we're not new to the game here on the scopes disclosures or other ESG factors. So I think that helps our industry as we get ready and get prepared for this SEC rule. One of the things that we've always has been sort of the guiding principle for us on the template was that we wanted to make sure that what we were putting was responsive to investors' needs and providing them the information they need to make actionable decisions one way or the other. And obviously, our member companies are the most capital intensive that there are. So we're in the capital markets every day. The industry, in terms of climate, we have reduced our carbon emissions more than any other industry or sector, really more than most other countries. And, that trajectory is continuing. Almost all of our member companies have made climate goals. And electrification ultimately is probably going to be one of the main answers to climate change. So we feel like the future is bright, and we really wanted to utilize our reporting as a way to kind of highlight that trajectory for the industry. So having said that, when the rule first was released in draft almost really 2.5 years ago, it's been a while, we didn't think the rule quite hit the mark at the time because ultimately what investors were always telling us was that they wanted the information presented to them in a concise and comparable way. They didn't want to be overwhelmed or have too much information overload. And I think as the rule was originally conceived, it was a little bit too much in that direction. So, we think that the SEC made some really laudable improvements. And I definitely want to thank Paul and Erik for their explanations today, because I think there's a lot more of that to come as corporates and other investors look at these rules and implement. I will mention we had a call with the Big Four and our member companies and some SEC experts as well, and we had over 500 people on that call as well. So there's a lot of interest, a lot of questions. But as was said at the top of this webinar, we're preparing for compliance. That's kind of our posture. So having said that, yes, we believe in some of the improvements made for the rule with the rule. We think the removal of scope 3 was appropriate. In our sector, scope 3 is not that big of an issue, but the inherent, the inherent inaccuracy and the inconsistency within scope 3 is what really caused a lot of concern amongst investors. And frankly, I've never heard from investors saying they want more of that, at least from us. So I think that was appropriate to remove scope 3. I think also pushing back the assurance requirements was a smart idea. Obviously, whatever goes into the SEC documents under Sarbanes-Oxley needs to be 100% accurate. So we didn't, and all of our scope emissions are reported to other regulatory agencies such as EPA. So we have extremely high degrees of confidence and assurance in the numbers that we're reporting already on a voluntary basis on scope 1 and scope 2. So we didn't see that as, we saw that assurance requirement as just something that layered expense on, but wasn't necessarily that important. And so we recommended they sort of made it more voluntary, the assurance piece. But anyway, I think it was wise for the SEC to push that out, partly because just having the infrastructure in place on the accounting side to make that assurance would probably be a stretch, even, given the compliance complexity and burdens that we're going to have just putting the rule in place. So I thought that was a good idea. Also, compliment the SEC on what they did. One of the comments we made was that in the normal reporting to EPA on our emissions, there was a timing difference between when the K is filed and when the reporting is done to EPA. So they acknowledged that, and they allowed for some flexibility there. So we thought that was a positive development as well. On the SX side, that was the part where I thought, it really needed a lot of work. Obviously, one thing we like just in general is the idea of going with the Supreme Court classic definition under Northway of financial materiality. We thought that was appropriate. We thought also the elimination of the line by line plus minus sort of disclosures that were originally envisioned was also very appropriate, because one of the things I tell people is that my mom is an investor in utilities. And so when she goes to pick up a 10K, if she saw 30 or 40 pages of disclosure footnotes plus minus on these things, I think in her case, it would definitely be information overload. And obviously there's a lot of sophisticated investors out there also, but at the end of the day, I feel like that you need to have a rule that also meets the needs of the retail investors. So striking that balance is very important, and we don't want this information to obfuscate the true story and nature of those companies. And so I think SEC, in making the changes that they made to Reg SX, move that in an appropriate direction. So, and again, the only thing I would say in terms of improvements to the rule, I still think that 1% threshold for the disclosure there, probably you could even just take that out and rely on the materiality number, because I don't know of any, at least in my history of looking at these things and engagement in the industry, I've never seen anything at 1% that's financially material in any context. So I think that, going with that traditional definition is a good idea. You mentioned, I think, Jake, in your Q&A about this idea of perhaps, goals looping in scope 3 in terms of materiality. That is a concern. And I think that it was good that there is a safe harbor in the rule for those that have goals and in transition plans. Almost all of our members have goals. But what you don't want to see in the rules is something that sort of inhibits people from making those goals. Look, they're aspirational. Okay, people are leaning into those things. And I always feel there's going to be a future for our voluntary template, because there are things that belong in the SEC documents and things that belong outside the SEC documents. I think, to me, these aspirational targets are great. It's good that companies are leaning in and setting them, but I think that's a good place, an example of that. So again, I think the bottom line is we want to see these disclosures be effective, be concise, be comparable, and be something that investors can really use to make their decisions and not obfuscate the information. So it's a balancing act, I know, and I think, they definitely moved it in the right direction. So maybe I'll stop there.
Great, Rich, thank you very much. We
Thanks, Steve.
value working with EEI. Obviously, on some of the
Likewise.
specifics, we agree with you, and some we don't agree.
Likewise.
But I think moving it forward, I mean, your basic point about you and your members are moving towards compliance is exactly the issue. And
Yeah.
now we want the whole country to be moving to compliance in that area. So thank you very much, Rich. I'm going to shift. As we all know, there is no audience more important to the SEC than investors. And I'm going to introduce our Vice President of the Ceres Investor Network, Kristen Spalding, to give a brief comments on behalf of what she's hearing from investors.
Thank you so much, Stephen. So our investor network includes both asset managers and asset owners. And for all the years I've been working here at Ceres, and long before that, investors have needed information on material risks. They ask for this data, and the new rule really advances what they're going to be able to get in filings, but they're asking for this data because it's central to their fiduciary duty. Their duty to their clients, their beneficiaries, their pension participants. They're bound by their fiduciary duty to manage risk. And so understanding how climate risk is integrated into the risk management frameworks of the companies that they own and that they have debt with is critical. These rules really help the investors get that critical risk management and opportunity. The investors are looking for those long-term value creation signals. So that brings me to the next reason why investors are asking for this data. Companies create long-term value and improve returns when they're ahead of the risks, when they're looking for the transition opportunities. So over different time horizons, depending on how the investors invested, these investment decisions are better informed when they've got better data. Scopes 1, 2, and we believe 3, many of the investors are still asking for Scope 3 disclosures, will help determine which companies are going to outperform in the long run. I would say that investors in my network are really focused on how they incorporate this disclosure information into their investment decision making. So they're trying to decide how to allocate capital across different asset classes. They're making decisions about which securities belong in and out, depending on the investor's strategies. Sometimes they're looking for the best in class in a sector. Other times they're looking to manage risk across a broad index or broad set of portfolios. So regardless of the investor's strategy, what they're saying is better information helps us improve the long-term returns for our clients and beneficiaries. I would say, the last area where I'm seeing investors really excited about the disclosures that they're currently getting on a voluntary basis and that they anticipate getting as a result of this rule is informing their corporate engagement strategies. So investors now, I think, are engaging really year-round. It's not just the proxy resolutions that they're filing, but the dialogues that they're having with companies. And in those dialogues and resolutions, they've been for a long time asking for disclosures about climate risks, Scopes 1, 2, and 3, emissions data, the forward-looking transition plans that companies have. All of those disclosures are important to that corporate engagement. As they begin to get better data, they're going to be able to shift their engagement strategy so that now, instead of asking for show us what you have in terms of your disclosures, now they're going to be able to say, let's see the implementation. Let's really get to the action. Because investors tell me that the rubber hits the road when companies are moving, when they're actually addressing the risk. So it's important to see how the companies are planning and evaluating, but from an investor perspective, really what they want to see is how they're acting against those disclosures. So at least in my conversations with investors, they're really excited about the rule. They're going to continue to engage on these subjects with the companies in their portfolios. They're going to use the disclosures in robust ways, and we'll ask for voluntary disclosures where the rules don't go far enough. And we'll look forward to continuing to work with the SEC as the rules get implemented. Thanks, Stephen.
Thank you. So let me now introduce Laura Drucker, our Senior Director of Corporate Admissions. Laura.
Thanks, Stephen. Yeah, as Kirsten said, investors are bound by financial duty to manage risks, and a company's financial performance can be both positively and negatively affected by material climate-related risks. So if we flip that to the corporate perspective, companies need to be managing risks in a way that not only minimizes negative financial performance, but that also maximizes opportunities to reduce emissions and risks in ways that positively impact financial performance. Understanding where emissions and risks impact a company's value chain, setting goals, and developing plans to manage those risks as part of a company's core business strategy is best practice in corporate climate management. Just as an example, Unilever recently published an updated transition plan, and they credit proactively managing their transition to net zero as helping them increase resiliency, improve efficiency, and allowing them to future-proof their value chain against transition risks, such as carbon prices, while sparking innovation and helping to attract the best talent. So by having and implementing a transition plan, Unilever is minimizing the downside and maximizing the upsides of managing transition risks. As we heard earlier, the SEC disclosure rule requires companies to disclose material transition risk. They're also, and if they have a plan, they're required to describe that plan. So there's a clear opportunity for companies to showcase their climate risk management in a consistent way to investors and other stakeholders. A clear message for companies, I think, is to get ready now. Start building up the systems and cross-organizational collaborations necessary to meet the requirements of the SEC. And as you start that preparation, make sure you're maximizing the potential of the rule by not focusing only on disclosure as an end goal. As soon as material transition risks are identified, companies should be making plans to manage those risks. And they should do this with the full company value chain in mind to avoid leakage of risks or missed opportunities. So while Scope 3 emissions are not required to be disclosed to the SEC, transition risks that impact value chains will. As Kirsten noted, the investor demand for understanding Scope 3 emissions will continue. And so companies that have already been estimating and disclosing Scope 3 emissions, of which there are many, should continue to do so. And companies that haven't should really get started. As Richard noted, for some companies in some sectors, Scope 3 may not be the most material emission source, but it's really hard to know that if companies don't estimate and understand those emissions first. And for many companies, just the exercise of understanding Scope 3 can identify transition risks and opportunities they may have not considered by looking at their own operations. I'll just close by saying some companies may be ahead, but all companies can catch up and use preparing for the SEC rule as a catalyst to not just identify and disclose climate risks, but to manage climate risks in a way that unlocks business opportunities. So hopefully I've gotten you excited about the potential of the rule. So I'll turn it back to you, Stephen.
Laura, thanks so much. And both of you have made several comments about the importance of investors, transition plans, and getting ready. It's now a special pleasure to have Ann Kelly, our Vice President of Government Relations. Ann?
Well, thank you so much, Stephen. And I think I'm offering the slide that many of you have been waiting for, which is our call to action. And I'm going to be very brief as we get to the close here. But we basically need you to publicly defend the rule. And I think you know why. And we've got a full menu here that we're happy to assist you on. The first is being a friend of the court. This is basically what we're inviting you to do, is to sign an amicus brief. And we're going to have 2 amicus briefs teed up, one for investment firms, one for companies. Understand, this does not make you a party to any lawsuit. You're not an intervener. You're simply joining a large, comfortable tent of colleagues who are demonstrating their support for the rule by signing a brief, amicus brief. Now, the sooner you can contact Randy Mail, my colleague, the better. Her email is here. You will have several weeks before this brief is filed. We're not certain of the exact court deadlines, but we'd love to have you express your interest, and we'd really like to get robust support on the part of the investor community and on the part of companies. Ceres has been through 2 rounds of recruiting investors and companies for amicus briefs over the last few years. We know the drill, and we will make this easy for you. Second, we'd love for you to contact your lawmakers. Federal lawmakers really need to hear from the leading business and investor community that the rule makes sense and that you'd like to maintain it and keep it in place. We can help you have behind the scenes meetings with members, with staffers. We've got a full team in DC. Very happy to talk to you about that and help you navigate exactly who to talk to and about what. In a more public way, we'd love for you to speak out. We'd love for you to make a public statement of your support. And this can be anything from a tweet, a blog, an op-ed, a long-form story, a press interview. Our comms team is ready to work with you to tailor a message that really works for your company, for your investment firm, given your leadership at this point. It would also be wonderful if you'd consider engaging your trade association, whether it's a single sector or multi-sector trade association. We'd love to see them step out as well. We'll help you to do that. Finally, as you know, we feel Scope 3 data is still critical. We know that investors still need and use Scope 3 data. Some of you are having to purchase it. Companies, we feel, should voluntarily support in line with California, EU, and international standards. No surprise that you're hearing that from Ceres. Thank you for all of your leadership, and any of these areas where you're able to participate, we will be most grateful.
Thank you, Ann, very much. We appreciate that. And again, I hope everyone thinks about ways you can both get ready and get involved in some way. Next slide, please. Just in the interest of time, we're going to send this out. We want your feedback. Was today helpful or not? How can we do more to reach out to you? Next slide, please. One of the things in the SEC rule that was talked about by Erik and Paul were the role of the boards. We have a course with University of Michigan about training boards. If you're interested, there's a link there. We can provide more information offline. Next slide, please. That we have an initiative, Freedom to Invest. Again, about we'd love to share more about that, freedomtoinvest.org. Next slide, please. In the interest of time, we are co-sponsoring with Greenfin. There's been lots of conversations there. Hope you'll consider participating. Many of you already are. Next slide is this is our 35th year. And again, hope you'll be able to join us on October 23rd. And last slide is deep thanks to all of our speakers, to all of you. Again, if there's additional questions, write to any of us or secrule@ceres.org. Thank you very much. Have a great day.